Go out.
It's not too deep as the ocean goes deep.
I'm talking about my son's life. And I'm talking about the lives of other black kids. Do what the hell you want to do. Go ahead. But you can't silence me. But you are not going to silence me.
We know that the government is running.
Hey everybody, I am your host, Texas Black Diamond, and thank you for tuning in to Texas Black Diamond ENT.
RICO prosecution against the defendant that was absurdly remote from the drafter's intent. Stretching the liberal construction clause well beyond the intent of Congress, the government constructed a RICO theory of prosecution designed not to effectuate the purpose of the RICO statute, but to prosecute the defendant for alleged misdeeds going back decades without pesky statutes of limitations obstacles. Adding to its history of Celebrity Mann Act prosecutions, the government extended the broad language of the Mann Act to conduct it against defendant. Where defendant's alleged transportation of females, largely consenting adults, was incidental to his travels as a world-renowned performer, he is not guilty of Mann Act violations. If the government intends to prosecute Mann Act violations in the fashion it did here, it might consider investigating the many influential, wealthy, mostly white, corporate leaders who frequently arrange travel for paramours who later conclude that the experience was less than pleasant. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 8 of 63 page ID hashtag 10905. 2. A detached and unemotional review of the evidence in this case shows that the government presented an overabundance of bad character evidence to compensate for its insufficient proofs of the specific elements of RICO and the Mann Act. Accordingly, this court must acquit defendant of the verdicts of guilt entered against him. Relevant facts: the government charged defendant with 1 count of racketeering based on 14 predicate acts and 8 standalone counts of violations of the Mann Act that were also charged as racketeering acts. With the exception of Racketeering Act 1, alleging the offense of bribery, the charged offenses involve conduct alleged by 5 women: Geronda, Jane Doe number 4, Jane Doe number 5, Stephanie, Jane Doe number 2, Sonia, Jane Doe number 3, and Faith, Jane Doe number 6. The jury returned a verdict convicting defendant of all charged counts, but acquitted him of those. Racketeering acts related to Sonia. Given the length of the record, defendant will incorporate relevant facts into the argument sections as appropriate. Argument: this court must set aside the verdict of guilt entered against the defendant and enter a judgment of acquittal where the government presented insufficient evidence of the offense of racketeering, count 1, and all Mann Act violations, counts 2 through 9. Federal Rule of Criminal Procedure 29(c) provides that, if the jury has returned a guilty verdict, the court may set aside the verdict and enter an acquittal. A court can enter a judgment of acquittal on the grounds of insufficient evidence only if, after viewing the evidence in the light most favorable to the prosecution and drawing all reasonable inferences in the government's favor, it concludes no rational trier of fact could have found the defendant guilty beyond a reasonable doubt. United States v. Reyes, 302 F. 3D 48, 52, 2D CIR 2002. To sustain a conviction, the jury must: Case 1:19 CR 00286 AMD Document 273-1 filed February 27, 22 page 9 of 63 page ID hashtag 10906. 3. Have been able to find each of the essential elements of the crime beyond a reasonable doubt. United States v. Jackson, 368 F. 3D 59, 63, 2D CIR 2004. As set out in detail below, defendant's RICO conviction cannot stand where the government failed to prove the existence of an enterprise, the activities of which affected interstate commerce, and a pattern of racketeering activity. Moreover, insufficient evidence existed to prove each and every element of the charged Mann Act violations by proof beyond a reasonable doubt. The government failed to prove defendant guilty of the offense of racketeering, count 1. This court must acquit defendant of the offense of racketeering where the government failed to prove defendant guilty beyond a reasonable doubt of each and every element of the offense. The government effectively swamped the jury with bad character evidence that was guaranteed to produce a guilty verdict, but its proofs on the charged offenses were insufficient as a matter of law. Ignoring the distinctly economic legislative history of the RICO statute, the government brought a RICO prosecution against defendant, not to remedy widespread criminal activity of an enterprise, but to punish one man whose alleged crimes could no longer be prosecuted by state and local agencies. The government's belated interest in protecting defendants' alleged victims does not justify application of the RICO statute to alleged private, sexual misconduct of the defendant, and only the defendant, even if some of that conduct could have been timely prosecuted by local authorities long ago. As a reminder, RICO's primary purpose was to combat organized crime by prosecuting the highly diversified acts of a single organized crime enterprise under a RICO's umbrella. The overarching goal of the statute was to curb the infiltration of legitimate business. Case 1:19 CR 00286 AMD Document 273-1 filed February 27, 22 page 10 of 63 page ID hashtag 10907. 4. Organizations by racketeers. In its statement of finding and purposes accompanying the RICO statute, Congress declared the following. The Congress finds that 1. Organized crimes in the United States is a highly sophisticated, diversified, and widespread activity that annually drains billions of dollars from America's economy by unlawful conduct in the illegal use of force, fraud, and corruption. 2. Organized crime derives a major portion of its power through money obtained from such illegal endeavors in syndicated gambling, loan sharking, the theft and fencing of property, the importation and distribution of narcotics and dangerous drugs, and other forms of social exploitation. 3. This money and power are increasingly used to infiltrate and corrupt legitimate business and labor unions and to subvert and corrupt our democratic processes. 4. Organized crime activities in the United States weaken the stability of the nation's economic system, harm innocent investors and competing organizations, interfere with free competition, seriously burden interstate and foreign commerce, threaten the domestic security, and undermine the general welfare of the nation and its citizens. And 5. Organized crime continues to grow because of defects in the evidence-gathering process of the law inhibiting the development of the legally admissible evidence necessary to bring criminal other sanctions or remedies to bear the unlawful activities of those engaged in organized crime, and because the sanctions and remedies available to the government are unnecessarily limited in scope and impact. It is the purpose of this act to seek the eradication of organized crime in the United States by strengthening the legal tools in the evidence-gathering process, by establishing new penal prohibitions, and by providing enhanced sanctions and new remedies to deal with the unlawful activities of those engaged in organized crime. Organized Crime Control Act of 1970, 1 of PUBL.L. No. 91 to 452. Callan v. State Chemical Manufacturing Company, 584 F. Sup. 619, 621, ed. Pa. 1984. Admittedly, prosecutors have used RICO in a wide variety of circumstances under the statute's liberal construction clause. H.J. Inc. v. Northwestern Bell Telephone Company, 492 U.S. 229, 248. 49, 1989. The liberal construction clause notwithstanding, the Supreme Court has acknowledged that the clause is not without limits. Reeves v. Ernest and Young, 507 U.S. 170, 183. 1993, as the court held in Reeves, the liberal construction clause was not an invitation to apply RICO to new purposes that Congress never intended. The government clearly exceeded those limits with this prosecution, as evidenced by its failure to prove the charged offense of racketeering. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 11 of 63 page ID hashtag 10908. 5. To sustain a conviction for RICO, the government must prove that the defendant, 1. Through the commission of two or more acts constituting a pattern of racketeering activity, 2. Directly or indirectly invested in, maintained an interest in, or participated in, an enterprise, 3. The activities of which affected interstate or foreign commerce. 18 U.S.C. Section 1962, c. As set out below, the government offered insufficient proof of all elements of the offense of racketeering. A. The government's proof did not establish an enterprise. The government's case was doomed from the start where it failed to plead and prove an enterprise. An enterprise includes any individual, partnership, corporation, association, or other legal entity, and any union or group of individuals associated in fact, although not a legal entity. 18 U.S.C. Section 1961, 4. The United States Supreme Court has defined a RICO enterprise as a group of persons associated together for a common purpose of engaging in a course of conduct. United States v. Turquette, 452 U.S. 576, 583, 1981. See also Boyle v. United States, 556 U.S. 938, 950, 2009. An enterprise is demonstrated by evidence of an ongoing organization, formal or informal, and by evidence that the various associates function as a continuing unit. First Capital Asset Management, Inc. v. Satinwood Incorporated, 385F, 3D 159, 173, 2D CIR 2004. For an association of individuals to constitute an enterprise, the individuals must share a common purpose to engage in a particular fraudulent course of conduct and work together to achieve such purposes. ID 174. The enterprise's purpose must be common to all of its members. Stein v. Worldwide Plumbing Supply Incorporated, 71 Sup. 3D 320, 325, EDNY 2014. See also Crab House of Douglaston v. Newsday, 801F, Sup. 2D 61, 77, E.D.N. Y 2011, citing Satinwood, 385F, 3D at 174. The enterprise is neither the individual defendant nor the pattern of racketeering activity. Rather, it is an entity separate and apart from the pattern of activity in which is. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 12 of 63 page ID hashtag 10909. 6. Engaged and must be alleged and proved separately. However, there must be a nexus between the enterprise and the racketeering activity that is being conducted. United States v. Indelicato, 865F, 2D 1370, 1384, 2D CIR 1989. Furthermore, the RICO enterprise must have an ascertainable structure separate and distinct from the pattern of racketeering activities. Turquette, 452 U.S. at 583. Finally, for Section 1962, C, purposes, the person charged with a RICO violation and the alleged enterprise must be separate and distinct from one another. This requirement flows from the statutory mandate that a person who engaged in a pattern of racketeering activity must be employed by or associated with the enterprise. Satinwood, 385F, 3D 159, 2D CIR 20014, Riverwoods Chappaqua Corporation v. Marine Midland Bank, INA, 30F, 3D 339, 344, 2D CIR 1994, Bennett v. U.S. Trust Company of New York, 770F, 2D 308, 315, 2D CIR 1985, Brannon v. Boatmans. First National Bank of Oklahoma, TBA, 153F, 3D 1144, 1146, 10th Circle 1998. An entity cannot simultaneously be the enterprise and the person who conducts its affairs, permitting that would be tantamount to permitting an entity to associate with itself. Bennett, 770F, 2D at 315, Hirsch v. Enright, 751F, 2D 628, 633, 3D CIR 1984, McCullough v. Suter, 757F, 2D 142, 144, 7th Circle. 1985, B. Common purpose. In its third superseding indictment, the government alleged that the defendant, his employees, managers, bodyguards, drivers, personal assistant, and runners, and other members of his entourage constituted the enterprise for RICO purposes. According to the government, the purpose of the enterprise was to 1. Promote defendant's music and his brand, 2. Recruit women and girls to engage in illegal sexual activity with the defendant, and 3. Produce pornography, including child pornography. The government did not allege that the enterprise. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 13 of 63 page ID hashtag 10910. 7. Constituted a legal entity, but rather an association of individuals. DKT number 43, superseding indictment, as held in Satinwood, Supra, for an association of individuals to constitute an enterprise. The individuals must share a common purpose to engage in a particular fraudulent course of conduct and work together to achieve such purposes. Emphasis added. Thus, for the government to establish an enterprise here, it was required to prove that defendant, his employees, and entourage came together with the common purpose of recruiting women and girls to engage in illegal sexual activity and produce pornography, not merely the broader purpose of promoting defendant's music or brand. Assuming the defendant's employees and entourage did share a common objective of promoting defendant's music, that objective had no nexus to the underlying racketeering activity. Indelicato, 865F, 2D at 1384. Defendant did not go through all the trouble of becoming a world-famous R&B singer for the purpose of engaging in illegal sexual activity, even if his job put him in proximity to women. The government cannot run the common purpose requirement by identifying a broad objective of the enterprise unrelated to any fraudulent activity with no nexus to the racketeering activity. The government's evidence of an enterprise was insufficient because it failed to establish that defendant's employees and entourage shared the common purpose of recruiting women to engage in illegal sexual activity with defendant that included creating pornography. Notably, the government does not define illegal sexual activity, but based on the predicate acts charged, the government contends that defendant's employees and entourage shared an objective of ensuring that defendant had his sexual needs met by women, some but not all underage women, while at home and while traveling, was able to control these women to engage in sexual conduct. The government deems abusive, was able to videotape his sexual activities with these women. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 14 of 63 page ID hashtag 10911. 8. And could expose his sexual partners to herpes. To be clear, the government contends that making sure that defendant's sexual needs were met was the objective of the enterprise, in addition to promoting his music and brand. Conceitedly, the government offered evidence that defendant's various employees carried out some tasks that related to connecting the defendant to women with whom he had a personal, even sexual, relationship, or with women whom he was interested in having a sexual relationship. These tasks included providing defendant's phone number to women who attended his concerts, inviting women to after-parties, arranging for travel for defendant's female guests, and ordering food for those guests while they visited his property. However, the record is devoid of evidence that the members of the enterprise acted with the common objective of ensuring that defendant engaged in illegal sexual activity. It is true that RICO does not have a mens rea requirement beyond what is necessary for proving the predicate crimes. Berner Corporation v. R.A. Brunner Company, 133F, 3D 491, 495, 7th Circle. 1998, but where the government's evidence of an enterprise centers on its claim that the associated in fact members shared a common purpose of ensuring defendants' illegal sexual activities, the government must offer some evidence that the members of the enterprise knew that their actions were promoting not just legal sexual activities, but illegal sexual activities and the production of pornography. Put in terms expressed in Satinwood, the government was required to show that the individuals who made up the enterprise shared a common purpose to engage in a fraudulent course of conduct. To share a purpose requires the members to agree on what that purpose is. Defendant is not claiming that each member of the enterprise must have possessed knowledge about every predicate act that the defendant is alleged to have committed, but the Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 15 of 63 page ID hashtag 10912. 9. Government cannot prove a common purpose without showing that the members of the enterprise shared an understanding of what that purpose was, which according to the government was promoting illegal sexual activity and producing pornography. Despite its bullying tactics, the government came up short on evidence that all of defendant's employees who made up this vague enterprise were working as a continuing unit to ensure defendant could engage, not just in sex, but illegal sex. No employee testified that she understood that their purpose in the enterprise was to recruit underage women, nor did any member of the enterprise present any testimony that they had any knowledge about defendant's herpes diagnosis, that he practiced unsafe sex, or that he videotaped his sexual experiences. The government can point to no evidence that any employee possessed specific information about what precisely transpired in defendant's bedroom once he was alone with his female guests. Even if defendant's employees knew that defendant expected his guests to follow strict, even controlling, rules, and possessed recording devices like iPads and iPhones, it does not follow that the members of the enterprise shared a goal of promoting illegal sexual activity. C. Enterprise distinct from racketeering activities to the extent the government argues that its evidence showed that the members of the enterprise shared a common purpose and had knowledge of promoting the defendant's illegal sexual conduct. The government has failed to demonstrate that the purpose of the enterprise was distinct from the racketeering activities. United States v. Smith, 413 F, 3D 1253, 1267, 10th Circle. 2005. United States v. Keltner, 147 F, 3D 662, 668, 8th Circle 1998. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 16 of 63 page ID hashtag 10913. 10. D. A person enterprise rules separately. The government was required to demonstrate that defendant was distinct from the enterprise. It is axiomatic that Section 1962, C, clearly envisions that the person and the enterprise will be distinct. Bennett, 770 F, 2D at 315. This requirement focuses the section on the culpable party and recognizes that the enterprise itself is often a passive instrument or victim of the racketeering activity. ID. The United States Supreme Court has held that a RICO defendant must have participated in the conduct of the enterprise's affairs, not just his own affairs. Cedric Kushner Promotions, Limited v. King, 533 U.S. 158, 163, 2001. The government cannot plead its way around the distinctness requirement by simply alleging that the enterprise is defendant's inner circle and introduce a series of headshots of all of defendant's former employees as evidence of an enterprise. The enterprise, as alleged by the government, existed because of its goal to promote the defendant in his legal and alleged illegal sexual activities. It had no function unrelated to the defendant. Under this factual pattern, the distinctness requirement was not satisfied. Because the government's RICO prosecution under this fact pattern is entirely unique, there is a dearth of factually analogous authority on this issue. That said, guidance offered in factually dissimilar cases leads to the clear conclusion that the government failed to prove an enterprise distinct from the defendant. In Riverwoods, Supra, the plaintiff Riverwoods Chappaqua Corporation, Riverwoods, claimed that through acts of extortion and mail fraud, the defendant Marine Midland Bank coerced Riverwoods to restructure loan agreements between
Hello, everyone. I put it on pause for a minute. This is the new motion she had to rewrite. Somebody just put in there that, let me see, it's the same one. It just had to be resubmitted. I know that, but what I've been trying to do, I haven't been able to sleep. I still can't sleep at night. So I decided to, take the time to click the thing, spend my money, and upload it so you guys can, have it for yourself, hear for yourself, and, dissect it for yourself. And that's all I'm doing. I'm just trying to come in and keep everybody updated. This is I think Judge Ann, she denied it or something like that, which y'all already know how she is, but it's rewritten. I hear a lot of new things in it, so it's not the same thing. So yeah, I I might seem a little grouchy to everybody. Forgive me for that because I have not been able to sleep. The doctor even put me on medication to put me to sleep, and I cannot. But I mean, I'm just taking the time to post this, for his supporters. So I just appreciate people, if you just take it for what it is. I don't care if it was something that was done in 2020. I'm just trying to put the information out there for the supporters. Appreciate that, and that's just nerve wracking to me. You know, I know it's just a redo, and a lot of the stuff in here I'm hearing is kind of different from what I read with the first one. So this is my first time hearing it just as well as everybody else. I'm like, hey, they just dropped a new motion, a new filing. So let me go ahead and post it for his supporters. And that's all I'm doing. So I just appreciate when you come on here, just come on here, you know, with, thanks, That's it. Welcome to the chat, you guys. I appreciate it, That's it give some credit sometime. Nerve-wracking. I hope I can start it over. I don't know what happened. Oh, push play.
Riverwoods and Westchester Federal Savings, later acquired by Marine Midland. Riverwoods, 30F, 3D at 341. Riverwoods purchased a property in Newcastle, New York, to develop residential condominiums and obtained a loan from Westchester Federal Savings made A. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 17 of 63 page ID hashtag 10914. 11. For that purpose. ID at 341-42. Marine Midland later acquired Westchester Federal Savings and inherited the loan agreement. According to Riverwoods, shortly after the acquisition, Marine Midland officers made it clear that they intended to dishonor the existing agreement and that they engaged in extortive behavior to force Riverwoods to enter into a new loan agreement with terms more favorable to Marine Midland. ID at 342. In its complaint, Riverwoods alleged, inter alia, that through a pattern of racketeering activity, Marine Midland and two of its loan officers participated in the affairs of an association in fact enterprise known as the Restructuring Group, in violation of 18 U.S.C. Section 1962, c. The Second Circuit reiterated that under the plain language of the statute, the RICO person must conduct the affairs of the RICO enterprise through a pattern of racketeering, and that the person and the enterprise referred to must be distinct. ID at 344. The court emphasized that a corporate entity may not be both the RICO person and the RICO enterprise, acknowledging that the distinctness requirement could be satisfied where there is partial overlap between the RICO person and the RICO enterprise, and that a defendant may be a RICO person and one of a number of members of the RICO enterprise. ID citing Cullen v. Amarjota, 811F, 2D, 698, 730, 1987. However, by alleging a RICO enterprise that consists merely of a corporate defendant associated with its own employees or agents carrying on the regular affairs of the defendant, The distinctness requirement may not be circumvented. ID. Finding that the Riverwoods had failed to prove the distinctness requirement, the Riverwoods Court observed that because a corporation can only function through its employees and agents, any act of the corporation can be viewed as an act of such an enterprise, and the enterprise is in reality no more than the defendant itself. ID. See also Brittingham v. A Mobile Corporation. 943F. 2D 297, 301, 3D CIR 1991. Where employees of a corporation associate together to. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 18 of 63 page ID hashtag 10915. 12. Commit a pattern of predicate acts in the course of their employment and on behalf of the corporation. The employees in association with the corporation do not form an enterprise distinct from the corporation. ID. The Riverwoods Court scoffed at the notion that the plaintiff seriously contended that the actions of the restructuring group were anything other than the activities of Marine Midland employees carrying out the business of that bank. ID. The court reasoned, both the allegations in the complaint and the proof at trial showed that the individual members of the restructuring group were employed by Marine Midland at the relevant times. Those employees were acting within the scope of their authority as officers of Marine Midland, and all of the actions taken by the restructuring group, such as negotiating and executing the restructured loan and exacting personal guarantees from Shapiro, were undertaken on behalf of Marine Midland and were directly related to the bank's business. ID at 345. The Second Circuit reached a similar conclusion in Diskin Incorporated v. 9X Corporation, 93F. 3D 1055, 2D CIR 1996. There, Diskin Incorporated was a New York corporation whose primary business was to provide removal services to telephone companies. ID at 1057. Diskin argued that the defendant 9X, a holding company that controlled subsidiaries MECO and NYTEL, collectively, the 9X defendants, conspired with AT&T Technologies to eliminate Diskin from the market removal services by defrauding the public. ID at 1058. Diskin sued the 9X defendants for civil RICO, alleging that the 9X group, which consisted of 9X, MECO, and NYTEL, were three separate corporate persons that conducted the affairs.
Do you guys want me to skip it to her breaking it down with the accusers? Just put a one up if you want me to skip the intro, her presentation. But it's good information. You know, we can learn a lot from that. We can always go back and look at it, see what case it is and stuff. You know, she's citing different cases and stuff like that. So if you guys want me to skip it, just let me know, because it's like 65 pages and I know it's late. Because I know I'm going to be up and I know people have to go to work, but you can always rewind back. Okay, let me try to skip it. I'm on my other software, so just be a little patient with me, because I am kind of drugged up too. So just be a little patient, because I am a little grouchy. Yeah. So let's skip, apply. Okay. The government failed to prove the so-called enterprise. So she calling us so-called enterprise. Let's see. I'll just come back and listen to it later on. Else the government proof did not establish a pattern of RICO. So she was explaining that. So basically, she's just breaking down why she believed. Okay, so this is the bribery part. So let's see if it'll play on this part.
Relatedness and continuity. 1. Racketeering Act 1, Bribery. the government failed to prove Racketeering Act 1 where insufficient evidence existed to prove that defendant caused Demetrius Smith to pay a public aid employee $500 to secure identification for Jane Doe number 1, Aaliyah. Despite blatant strong-arming by the government, Smith's testimony was inconsistent and vague about whether defendant was even present during any discussions about paying money to bribe someone for the fraudulent identification. Smith consistently testified that he discussed the prospect of bribing someone to obtain the fake identification with Daryl McDavid. R. 745. Smith did not obtain any money from the defendant and did not recall discussing it with him, although he allowed that he might have. R. 719. Whenever Smith failed to testify precisely as the government wanted, he was refreshed with his prior statements, not because he needed refreshing, but as a clear reminder that if he contradicted himself, he could be charged as a co-conspirator. That type of bullying pervaded Smith's examination and suggested that Smith's testimony may have been pressured by the government. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 25 of 63 page ID hashtag 10922. 19. After the subject matter had been discussed numerous times throughout Smith's testimony, the AUSA asked the following on redirect. Q. When you spoke to the group, as you testified on direct examination, when you spoke to the group about acquiring a state ID from the welfare office Aaliyah for money, the defendant was there, right? A. I'm pretty sure. I think so, but I'm not. I'm just not positive. Even if I said it before, I'm just not positive. I just don't see that in my head right now. R. 758. Not satisfied with that answer, the AUSA asked Smith again whether defendant was present when there was any discussion about a bribery. Despite his clear concern of facing legal repercussions for his testimony, Smith declared, I don't remember if Robert was there. If I said he was there before, I'm not changing that story to change the story. I'm just going back, and I'm just trying. I don't see it in my head, Robert next to me. R. 759. No rational juror could conclude that this less than convincing testimony provided proof beyond a reasonable doubt that defendant caused Smith to tender money to the public aid officer. Even if the evidence showed that the defendant turned to Smith for assistance in facilitating his marriage to Aaliyah, the offense of bribery requires proof that defendant at least knew of Smith's intent to bribe a public official and facilitated in the bribery in some way. The record is devoid of evidence that defendant knew how Smith obtained the identification or facilitated Smith in obtaining the identification. As far as defendant knew, Smith obtained the identification from a friend who worked in the public aid office. Without Smith's unequivocal testimony that defendant was part of the planning process of obtaining the fraudulent identification, the evidence was insufficient to sustain the bribery offense. Furthermore, Racketeering Act 1, bribery, lacks both vertical and horizontal relatedness. It was an isolated offense having no connection to the other charged acts or to the Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 26 of 63 page ID hashtag 10923. 20. Purpose of the enterprise itself. Indeed, as discussed, supra, the record simply fails to show that in 1994 any enterprise existed that had a common purpose of facilitating defendant's sexual desire for minors. Smith testified at length that he had no idea that defendant was involved in any type of sexual relationship with Aaliyah or any other young women. Smith was certainly part of defendant's close circle of confidants, but the mere identification of a group of people who worked for the defendant does not an enterprise make. Smith did not testify about any other conduct in which he engaged to advance the alleged purpose of the enterprise. Smith's conduct was nothing more than a singular event that bore no connection to the purpose of the enterprise, which did not exist in any event, and which bears no connection to the other racketeering acts. Furthermore, because the act did not occur within 10 years of any other predicate act. That was sufficiently proven. The act is time-barred. Racketeering Act 1 was not proved beyond a reasonable doubt. 2. Racketeering Act 2, sexual exploitation of a child, Stephanie. The government failed to prove Racketeering Act 2, that is, sexual exploitation of Stephanie, where it offered insufficient evidence that defendant used, employed, persuaded, induced, or enticed Stephanie to take part in sexually explicit conduct for the purpose of producing a visual depiction. The government contends that on a single occasion prior to her 18th birthday, defendant had sexual relations with Stephanie at his studio in Chicago, Illinois, and recorded the episode on a video camera. The government cannot produce the video or the camera on which it was allegedly recorded. To be clear, the defendant is alleged to have recorded a legal and seemingly consensual sex act under the law of the state of Illinois that was only a violation of 18 U.S.C. 2251a, because Stephanie was not 18 years of age. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 27 of 63 page ID hashtag 10924. 21. To demonstrate that defendant committed sexual exploitation of a child pursuant to 18 U.S.C. 2251a, it is not enough for Stephanie to simply allege that defendant recorded sexually explicit conduct. Stephanie offered no testimony that proved that defendant used, persuaded, induced, enticed, or coerced her into sexually explicit conduct. Stephanie had an ongoing sexual relationship with defendant before the video recording incident and after the video recorded incident. Although she described those sexual experiences in hindsight as humiliating, it does not follow that defendant did anything to persuade, induce, entice, or coerce her into the sexual activity that was recorded. In fact, Stephanie admits that defendant called her on the phone and told her that he was picking her up and that he wanted to make a video of us having sex and that he would be there shortly. RS 1643, to which Stephanie responded, "Okay." Although Stephanie clearly regrets this decision, her own testimony shows that defendant did not think but tell her he wanted to videotape them having sex, and she agreed. The government must prove that defendant did something more than just film the sexually explicit conduct. If the act of filming or recording alone was sufficient to sustain the charge, Congress would not have included a requirement that the defendant employ, persuade, indue, entire, or coerce. Furthermore, the government failed to prove that defendant acted with a purpose of producing a visual depiction of that conduct. Although the jury was erroneously charged that the government could sustain the charge by proving that the purpose was transmitting a visual depiction, the statute requires something different. Indeed, producing is defined by the statute as producing, directing, manufacturing, issuing, publishing, or advertising. 18 U.S.C. 2256(3). While the statute also prohibits the transmission of live visual depictions, defendant was not charged with transmitting a live visual depiction, and there is no evidence that he did. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 28 of 63 page ID hashtag 10925. 22. Lastly, the parties' stipulation that the film used in VHS tapes was a type of film that was not produced in Illinois is insufficient to prove by a reasonable doubt that the conduct was recorded on a device made in a foreign country or affected interstate commerce. Accordingly, the government failed to prove Racketeering Act 2 by proof beyond a reasonable doubt. 3. Racketeering Act 5, Mann Act violation, Geronda. The government failed to prove Racketeering Act 5 where there was insufficient evidence that defendant 1. Used a facility of interstate commerce to knowingly persuade, induce, entice, or coerce Geronda to engage in sexual activity that violated Illinois law, and that 2. Defendant knowingly committed the prohibited sexual activity. To obtain a conviction under Section 2422(b), the government must show that the defendant I. Used a facility of interstate commerce.
So I guess the prosecutors are Are they trying to say that Robert met this woman at the courthouse, you know, and then trying to say his camera came from China, New York, or different places, and he used that? And I don't understand how. Um, I don't understand how the jurors, accepted this, and it's just common sense. So it does question the jurors, because I went back and I'm gonna chop that video up where we went to New York, and I started talking to these people in New York, and everybody, you probably had some that was screamed out, he's a pervert. That's just somebody that hasn't done their research, but people that use their basic common sense. Even the white people was even saying, you know, I see bullshit. They talked about the lifetime of lies. So the prosecutors is basically saying that he met her at, somewhere, I guess, a federal type thing. Right now I'm just all over the place, so y'all forgive me. I'm even medicated up, but I wanted to, cut in on that and say, does that make sense for them to try to say that Robert met this lady, Geronda Pace, when Geronda Pace was lying about her age, fake ID, got into the courtroom. Robert didn't know anything about her. She became friends with his so-called friend Bubba Jermaine. Then she became friends with Dominique, which Dominique, we later learned that Arline and Dominique worked at the same place, and they knew each other. And so that was a big question mark over your head. And then for this trial to be this big and to go that long, for the jurors just come out just like, oh, he guilty, no, didn't dig deep, didn't try to, give more information, didn't try to read, ask for transcripts to try to read this or read that. And when I was telling you guys, when they were reading just that little part of Azriel's text message, I'm like, what the hell going on? Why we don't hear the conversation, the full conversation with her and her mother? What did the mother say? Because I was curious. I wanted to know, what did the mother say? So, now we know what the mother said. So all these little robots coming in, I will be blocking you, because I ain't got time for you, honey. I ain't in the mood. So it's just, this is why she took on the case. Like, we've been saying this, all along, like, something's not right. It's just something, it's just weird. And me working behind the scenes and working with people, witnesses, and they wasn't called, and then you had Nicole and them, and you would think that they would have all these witnesses and the depositions and stuff together. They didn't have that, and I didn't understand that. I'm like, do they feel that let's blow this for a mistrial? You rolling the dice. Mr. Cannon went in, and you can tell that he was doing his best to try to go with the flow and go with the little he know, because he only had 2 weeks to get this together. Then you have people like, well, he shouldn't have took on the case. Okay, if he didn't step in and you only had Nicole up there and she trying to tell Thomas to sit back and chill, she going in as the lead attorney, and she going up there saying you must find him guilty, and then she always had to be corrected by, Judge Sidebar. I went back and I read her opening arguments, and I'm like, what the hell are you saying? For the first time I was reading it, because I thought she had it together. I'm like, 2 years? I thought you had it together. I thought you were going to do, what Johnny Cochran did. He had it all night long. He was writing and he was, reading it out loud and changing up things, putting stuff in and taking stuff out just so it can be right. And this trial was not right. It was weird. Um, the journalists couldn't believe it, and so they got frustrated. And they was like, "The hell with it!" And they moved on to something else. And so you just have to wonder what the hell happened. And then you had Judge Sidebar. You listening to her, and she agreed with everything the government said, but always denying things the defense is trying to put out there. And it was just weird. And I have my videos where I talked about it. It didn't make any sense. So Miss Bunjean see what we see, and she crossed her T's and dotted her I's, and Judge Sidebar still tried to have her panties up her ass and trying to give her a hard time. So you can see that she cut it short with Demetrius Smith. Seems like she cutting it short with this Geronda Pace. So she's, trying to put this information out here, but she did come back and tell, Judge Ann, this is a big case, and you got a lot of, discovery, and you have a lot of, bad act witnesses, and, all these different things. So I have to address it. So you telling me I done did 65 pages and I shouldn't do 65 pages. Like, Judge Ann, we know, says she have her rules, and her rules says that if you're going to go over 25 pages, I believe that was, I can't remember the number. Hey, but it is what it is. Let's continue to be as long, but y'all can always come back and fast forward, rewind. But I'm stuck, and I'm just trying to share the information with you guys. Awesome. Let's get in the interview. No, nobody talked about it. And we waiting on them to talk about it.
Commerce. 2. To knowingly persuade, induce, or entice. 3. Any individual who is younger than 18 years old. 4. To engage in sexual activity of a criminal nature. United States v. Brand. 467F. 3D 179. 201-02. 2D-CIR 2006. First, the government did not prove that defendant used a facility of interstate commerce to persuade Geronda to engage in aggravated criminal sexual abuse between May 2009 and January 2010. Defendant contends that purely interstate use of cell phones does not constitute use of a facility of interstate commerce. United States v. Lopez, 514 U.S. 549, 1995. Gonzalez v. Reich, 545 U.S. 1, 2005. There are limits on Congress's power to create federal criminal prohibitions on traditionally state-regulated spheres of non-economic activity. But see United States v. Giordano, 442F, 3D 31, 40-41, 2D CIR 2006, finding that the jurisdictional element of Section 2425 is satisfied by interstate use of a telephone capable of transmitting communicates between states. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 29 of 63 page ID hashtag 10926. 23. Even if purely interstate use of cell phones constituted use of a facility of interstate commerce, the government's evidence that defendant called Geronda on a telephone is not sufficient proof that he used the facility of interstate commerce, a cell phone, according to the government, to knowingly induce, persuade, entice, or coerce Geronda to come to Olympia Fields to engage in prohibited sexual activity. The government provided no text exchanges showing that defendant used any words to induce, persuade, entice, or coerce, nor did Geronda testify that during any telephone conversation or on any text messages did defendant use words for the purpose of inducing, persuading, entice, or coercing her to come to his home or studios for prohibited sexual activities. Under the plain reading of the statute, there must be a nexus between the use of the cell phone and the words of persuasion, enticement, or coercion to satisfy A. Section 2422(b) violation. For example, if defendant called Geronda and invited her to a party at his home, and then once there, he coerced her into prohibited sexual activity that does not constitute a Mann Act violation pursuant Section 2422(b), since the defendant did not use the facility of interstate commerce, the cell phone, to coerce or induce her into the prohibited sexual activity. Use of the cell phone for some unknown communication coupled with a subsequent prohibited sex act is not sufficient to establish a violation of Section 2422(b). Lastly, if defendant really believed that Geronda was 17 when they engaged in sexual activity and that belief was reasonable, then he would not be guilty of aggravated criminal sexual abuse. R. 4351. Taking the evidence in the light most favorable to the prosecution, no reasonable juror could conclude that defendant knew that Geronda was 16 years old when they allegedly engaged in sexual activity between May 2009 and January 2010. Geronda turned 17 years old in April 2010. Government's Exhibit 70, which depicts a photo of Geronda, would fail to put any reasonable person on notice that she was 16 years old rather than 17 years old. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 30 of 63 page ID hashtag 10927. 24. The record reflects that Geronda habitually lied about her age. When she was 15 years old, she befriended a 23-year-old woman with whom she would attend defendant's Illinois State Court appearances in 2008. To gain access to those court appearances, Geronda had to demonstrate that she was 18 years of age, presumably by showing an identification. After using her older connections to get invited to a party at defendant's home in Olympia Fields, she sought out the defendant and falsely told him that she was 19 years old. To be clear, there is no evidence that defendant sought out Geronda. Geronda implausibly claims that after going through all the trouble of lying about her age to get close to defendant and past his security team, she decided to disclose her true age of 16 immediately after their first sexual encounter. Geronda claims that defendant was indifferent to her age and continued to engage in sexual relations with her until January 2010. The government's evidence falls painfully short of proving that defendant did not reasonably believe that Geronda was 17 years old at the time of their alleged sexual activities. The government allegedly recovered a copy of Geronda's fake ID and birth certificate in a storage facility purportedly belonging to defendant. Rather than reach the obvious conclusion that Geronda provided a fake ID to defendant's security team to gain access to the home, the government alleges that defendant or someone in his inner circle went through the trouble of altering her ID and photocopying it. No rational juror could conclude that defendant engaged in sexual activities with Geronda with the understanding that she was not of legal consenting age. 4. Racketeering Act 6. Forced labor is Geronda. No rational juror could conclude based on the evidence adduced at trial that defendant knowingly obtained or agreed to obtain any labor or services from Geronda on January 23, 2010. A conviction of forced labor under 18 U.S.C. Section 1589 requires the government to prove. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 31 of 63 page ID hashtag 10928. 25. Beyond a reasonable doubt that 1. The defendant obtained the labor or services of another person, 2. Through, inter alia, threats of serious harm, and 3. The defendant acted knowingly. United States v. Marcus, 487 F. Sup. 387, 310, EDNY 2007. The language by means of contained in the Forced Labor Statute, 18 U.S.C. Section 1589, A, requires the government to establish a causal link between the labor and services provided by the person and the threat of serious harm. ID serious harm, for purposes of Section 1589, A2, is defined as a New York harm, whether physical or non-physical, including psychological, financial, or reputational harm, that is sufficiently serious, under all the surrounding circumstances, to compel a reasonable person of the same background and in the same circumstances to perform or to continue to performing labor or service in order to avoid incurring that harm. Muchaira v. Al-Rawaf, 850 F. 3D 605, 618, 4th Circle 2017. Section 1589 is intended to address serious trafficking, or cases where traffickers threaten harm to third persons, restrain their victims without physical violence or injury, or threaten dire consequences by means other than overt violence. ID. The harm or threat of harm, considered from the vantage point of a reasonable person in the place of the victim, must be sufficiently serious to compel that person to remain in her condition of servitude when she otherwise would have left. ID. Part of a fair reading of statutory text is recognizing that Congress legislates against the backdrop of certain unexpressed presumptions. United States v. Toviev, 761 F. 3D 623, 628, 6th Circle 2014, Section 1589, the Forced Labor Statute, was passed to implement the 13th Amendment's prohibition against slavery or involuntary servitude. United States v. Toviev, 761 F. 3D 623, 629, 6th Circle 2014. Congress intended to reach cases in which persons are held in a condition of servitude through nonviolent coercion as well as through physical or legal coercion. Muchaira, 850 F. 3D at 617. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 32 of 63 page ID hashtag 10929. 26. According to the government, on an isolated date in January 2010, defendant violated the forced labor statute by using threats of violence to obtain labor, an act of oral sex, from Geronda. The forced labor statute was not intended to reach isolated conduct like that described by Geronda. Accepting the government's evidence in its best light, Geronda described an isolated incident in which the defendant allegedly assaulted her because he was angry that she was on her phone and did not properly acknowledge him when he entered the room. Geronda claimed that defendant slapped and choked her because he didn't believe that I was texting a friend and he got mad about it. R-176, Geronda testified that after the purported assault, she sat down with defendant in the VIP room and he instructed her to perform oral sex on him. Geronda.
Let me pause this, you guys. Geronda Pace is repeating what other people are saying. She and to me, I was thinking about this. I'm like, did Dominique, still had a relationship with Geronda Pace? Did she have still have a relationship with her? Did she call her and tell her what's going on? Do you remember when Dominique said that they were at a party and it was like it was time to go and he was telling her, she said she was he was like, it's time to go, let's go, and she didn't want to leave, and and they got into it, and stuff like that. A lot of this stuff is like she's repeating what other people are saying, and that's what I'm saying here. This is unfair to him because you had all these people, coming out on public, platforms and speaking and saying this and saying that, and then you have Gail King, stating, well, all these women are saying the same thing. Hell, because everybody biting off each other. Everybody is biting off each other. And he had a relationship with women with different personalities, for different reasons. So everybody experienced the same thing. And you had this lady jumping over the gate, and according to the trial friend, it was totally different from what she said in court. And that's another thing, having the trial friend to get up there and debunk the ID. That's what was weird, because we had people calling, and I'm listening to the conversation, and they said they didn't have the witness list. And I'm asking one of the witnesses, I'm like, what the hell is this? I said, I'm kind of concerned. I'm nervous. Like, why the hell they don't have the witness list? And they was like, I don't know. That's why I wanted you to hear, because I'm calling. I'm ready. They haven't. I said, have they called you to get a deposition? Have they called and talked to you? I know the truth doesn't need rehearsal, but they need to know what y'all know, what y'all can. So when they get up there, they can go full force. And it was just weird. I couldn't believe it. I couldn't believe that they didn't have a witness list. And then one witness told me that, well, they told me that Robert, was like, didn't want me to testify because he was worried or something like that. It wasn't about him or this person saying something against him, but he was worried about him and he didn't want them involved in it. And I'm like, who told you this? And I'm like, if you didn't hear from him, don't listen to nobody else. Call the attorney. I've been trying to call the attorney. I leave a message for the attorney. And I don't trust Nicole anymore. That's how it was behind the scenes, guys. It was just, when I say weird, it was weird. Trust and believe me, it was weird. They did not even have a witness list. And I think, what was the guy name that was the witness for Robert? And he was speaking on his behalf, and he's, Julius. Someone told me that Julius was, kind of pissed off because he was wondering why nobody else testified, and that they just asked him, do you want to testify on the behalf, just out of the blue, just ask him, like, do you want to testify? Then say, can you come testify? They gave him the option, do you want to testify for Robert? And it none of that made any sense to me. And then we had some of the witnesses trying to play dodgeball because you had the DA trying to subpoena them, and they dodged in the subpoena. And then from what I'm hearing about Dominique, she was the one that had the panic attack, but they used that to their advantage to try to say she had a panic attack and she was afraid to face him and stuff like that. Well, I felt like, from the information that I have in the text messages and the conversation with Dominique, and I have those conversations, she said she loved him, but she was upset because he she was there from beginning and he chose somebody else, and that's what she was upset about. But she said he does not deserve to go to jail. She said she tried to dodge the prosecutors because they was trying to get in contact with her, and I'm pretty sure her mother made sure that the prosecutors got in contact with her and got a subpoena so she can get a free trip to New York, you know. But she played that very well. Allegedly, she was the one that was up in there having those anxiety attack because she wasn't trying to get up there. But my question was you trying to not get up there because some stuff was gonna come out about you and Arline and Geronda Pace and other people? Is that why you flipped the script? You know? So it's just listening to this and it just bringing back thoughts and things that we was listening to going through the trial and before the trial, and it was very weird. So for people that wasn't following this, they don't understand and they don't see what we see, but we was calling the BS from the beginning, because we followed the case very well. We, did our research and talked to people and talked to people in the camp and, tried to put things together the best way we knew how. So this case, I'm glad she see what we see. Um, Also, to my knowledge, I'm just I don't want to talk too much about it, but Bonjean's gonna be fighting hard for the case. Just know that, and that's all I can say about that. Um, you don't want to say too much about things. You don't. I don't want to jinx anything, so I want to be as careful as I can. Not putting information out there that the the ops can use to try to throw a monkey wrench in things. So it's just best sometimes not to talk too much. You want to have content. You want to, you know, say what you know, or and stuff like that to let people know. Like, I know this, but like I always been telling you guys, everything is not for ears, all ears. So things I know, I just have to keep to myself because I don't want to mess this up. I just want her to do her job and do whatever she needs to do. And also, I want to apologize for the coughing and sneezing, but for some reason, I used to can mute myself, and you can hear this the screen sharing, but for some reason, it doesn't do that. So I apologize, you guys, for that. I'm gonna try not to cut in, but I just, I can't remember things good anymore. So I just want to, like, when it comes to me, I want to speak on it. So you guys forgive me for butting in because this is 60 some pages long. So she's crossing her T's and dotting her I's on that. So.
Geronda complied with the instruction. Geronda did not testify that defendant threatened her, forced her, or even demanded that she give him oral sex. Geronda did not claim that she feared defendant would assault her again if she declined the request. Geronda then left defendant's home and never came back. The government did not establish a causal link between the isolated act of oral sex and any threat of physical violence. Any physical violence that occurred during that episode in January 2010 preceded Geronda providing oral sex to defendant. Geronda's testimony simply does not lead to the reasonable inference that she gave defendant oral sex because she feared physical violence. Geronda did not claim that defendant used any words suggesting she would suffer an assault if she did not provide him with oral sex, nor did she claim that she feared another assault if she refused his request for oral sex. Geronda did not even testify that she did not want to give defendant oral sex. As troubling as Geronda's story may be, the government still must prove the elements of the crime of forced labor by proof beyond a reasonable doubt. It. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 33 of 63 page ID hashtag 10930. 27. Would not have taken much for Geronda to make the causal link between the act of oral sex and her fear of physical assault by the defendant. But she simply did not provide that testimony. Absent clear expression of congressional intent, courts should resist the urge to transform the forced labor statute to cover the circumstances alleged in Racketeering Act 6, which bear virtually no resemblance to those paradigmatic forced labor cases and their victims. See Toviev, 761F, 3D 623, 626, 5th Circle 2014, describing prostitution, forced sweatshop work, and forced domestic service as paradigmatic forced labor cases. Geronda came and went as she pleased, even if defendant prohibited her from wandering his property at will. Defendant did not force Geronda into a condition of servitude through threats of physical force, and an isolated example of oral sex with an alleged abusive act is just not forced labor. 5. Racketeering Act 7. Sexual exploitation of a child, Geronda. The government failed to prove Racketeering Act 7, that is, sexual exploitation of Geronda. According to Geronda, during her 6-month sexual relationship with the defendant, he recorded her with a Canon video camera and on an iPhone. The government produced no images or metadata corroborating this claim. Rather, the government contends that evidence that defendant owned a Canon video camera and had an iPhone that had the ability to video is sufficient evidence to establish the elements of the offense. The government failed to prove that defendant used, employed, persuaded, induced, or enticed Geronda to take part in sexually explicit conduct for the purpose of producing a visual depiction. To demonstrate that defendant committed sexual exploitation of a child pursuant to 18 U.S.C. 2251, A, it is not enough for Geronda to simply allege that defendant recorded sexually explicit conduct. Geronda's testimony was insufficient to prove that defendant used, persuaded, induced, enticed, or coerced her into sexually explicit conduct. According to Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 34 of 63 page ID hashtag 10931. 28. Geronda, she had an ongoing sexual relationship with defendant before defendant allegedly video recorded here, a relationship that defendant would have no reason to believe was prohibited since Geronda misrepresented her age. Although Geronda describes those sexual experiences in hindsight as humiliating, it does not follow that defendant did anything to persuade, induce, entice, or coerce her into the sexual activity that was recorded. The government must prove that defendant did something more than just film the sexually explicit conduct. If the act of filming or recording alone was sufficient to sustain the charge, Congress would not have included a requirement that the defendant employ, persuade, indue, entire, or coerce. Furthermore, the government failed to prove that defendant acted with a purpose of producing a visual depiction of that conduct. Although the jury was erroneously charged that the government could sustain the charge by proving that the purpose was transmitting a visual depiction. The statute requires something different. Indeed, producing is defined by the statute as producing, directing, manufacturing, issuing, publishing, or advertising. 18 U.S.C. 2256, 3. While the statute also prohibits the transmission of live visual depictions, defendant was not charged with transmitting a live visual depiction, and there is no evidence that he did. Lastly, the government's affecting interstate commerce evidence was insufficient where it could not establish what device, if any, was used to make these recordings. 6. Racketeering Act 8, Mann Act violations. Jane, the government failed to prove that defendant committed Mann Act violations in connection with his sexual activity with Jane on or about April 28, 2015, and May 1, 2015, in the state of California. Jane was 17 years old in May 2015. She concedes that she misrepresented her age to defendant when she met him and kept her true age a secret until fall 2015. After meeting. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 35 of 63 page ID hashtag 10932. 29. Defendant in Orlando, Florida, in April 2015. Jane traveled to meet him in California at the end of April 2015. The government charged defendant with 2 Mann Act violations in connection with this trip, alleging first that defendant violated 18 U.S.C. Section 2421A. A. Racketeering 8A, transportation preliminarily. The government's use of the Mann Act under the present set of facts is unprecedented and unjustified. 18 U.S.C. Section 2421A provides that W. Hover knowingly transports any individual in interstate or foreign commerce, or in any territory or possession of the United States, with intent that such individual engage in prostitution, or any sexual activity for which any person can be charged with a criminal offense, or attempts to do so, shall be fined under this title or imprisoned not more than 10 years, or both. The government contended that defendant arranged for Jane to travel to California with the intent of willfully exposing her to a contagious, infectious, or communicable disease in violation of Cal Health and Safety Code Section 120290. The government failed to prove a Mann Act violation under Section 2421A, where it offered insufficient evidence that defendant 1. Transported Jane with the intent of exposing her to herpes, and 2. Committed a violation of Cal Health and Safety Code Section 120290 by proof beyond a reasonable doubt. I. Intent, because there is no link connecting defendant's transportation of Jane with an intent to expose her to herpes. Defendant cannot be guilty of a Mann Act violation. The 9th and 10th Circuit Courts of Appeal have held that to establish the intent requirement of the Mann Act violation, the government must prove that the illegal sexual activity is the dominant, significant. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 36 of 63 page ID hashtag 10933. 30. Or motivating purpose behind the transportation. See United States v. Kinslow, 860 F, 2D 963, 9th Circle 1988, United States v. Lukashov, 694 F, 3D 1107, 1110, 9th Circle 2012, United States v. Cryer, 232 F, 3D 1318, 10th Circle 2000. Similarly, in United States v. Hayward, 359 F, 3D 631, 3D CIR 2004, the Third Circuit approved the District Court's jury instruction that stated, it is not necessary for the government to prove that the illegal sexual activity was the sole purpose for the transportation. A person may have several different purposes or motives for such travel, and each may prompt in varying degrees the act of making the journey. The government must prove beyond a reasonable doubt, however, that a significant or motivating purpose of the travel across state or foreign boundaries was to have the individual transported to engage in the illegal sexual activity. In other words, the illegal sexual activity must have not been merely incident to the trip. ID at 637. In United States v. Campbell, 49F, 3D 1079, 5th Circle 1995, the Fifth Circuit analyzed the intent requirement of 18 U.S.C. Section 2421 and held that, in determining whether a dominant purpose exists, we instead ask whether the illicit behavior is one of the efficient and compelling purposes of the travel. ID at 1083. See also United States v. Vang, 128F, 3D 1065, 7th Circle. 1997, interpreting the dominant purpose standard to merely significant or compelling or efficient, United States v. Perkins, 948F, 3D 936, 8th Circle 2020, holding that to prove the intent elements under Section 2423A, the illicit behavior must be one of the purposes motivating the interstate transportation. The Second Circuit does not seem to have answered the intent question, but whether this court applies a true dominant purpose standard or merely a significant or motivating purpose standard, the result is the same. The defendant's alleged violation of a California health law prohibiting him from exposing a partner to herpes was incidental to the trip. There is no proof in this record that demonstrates that defendant's motivating purpose in transporting Jane to California was to expose her to herpes. In fact, the government cannot even show that the Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 37 of 63 page ID hashtag 10934. 31. Motivating purpose of the trip had anything to do with Jane. As Jane herself testified when asked, Q, and while you were 17, did you take additional trips to California with the defendant? A. Yes, I did. Q. And do you remember where you traveled to? A. I do not. Q. Do you remember what the purpose of your travel was for? A. He had shows. R. 888. In short, no rational juror could find that the government proved that defendant's intent to transport Jane to California was to infect with her herpes. 2. Violation of Cal. Health Safety Code Section 120,292. The government did not prove beyond a reasonable doubt that defendant committed a violation of the Cal. Health and Safety Code Section 120290, because the government charged defendant with a repealed version of the statute no longer in effect, a version that reduced the government's burden of proof. Prior to the jury charge in this case, defendant notified the court that the jury instructions did not reflect the elements of Cal Health and Safety Code Section 120290. The government acknowledged as much but argued that it charged defendant under the statute that was in effect in 2015. The government had no authority to charge defendant with a statute that was repealed or inoperative at the time of prosecution. United States v. Chambers, 291 U.S. 217, 223, 1934. In case a statute is repealed or rendered inoperative, no further proceedings can be had to enforce it in pending prosecutions unless competent authority has kept the statute alive for that purpose. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 38 of 63 page ID hashtag 10935. 32. In 2015, Section 120290 of the California Health and Safety Code provided, except in provided in Section 120291 or in the case of the removal of an afflicted person in a manner the least dangerous to the public health, any person afflicted with any contagious, infectious, or communicable disease who willfully exposes himself or herself to another person, and any person who willfully exposes another person afflicted with the disease to someone else, is guilty of a misdemeanor. The statute was overhauled entirely in 2018 after the California legislature determined that it was antiquated, having been passed during an era of discrimination toward those afflicted with HIV. Point 2. The current statute bears little to no resemblance to the repealed 2015 version, least of all because it now requires a showing of a specific intent to transmit the disease. Although repealed or inoperative, the government proposed a jury instruction that attempted to reflect the elements of the 2015 statute. Apparently recognizing that the 2015 statute was unconstitutionally vague in any event, the government stepped into the shoes of the legislature and rewrote the statute to save it from a constitutional challenge. Thus, the government not only charged defendant with a repealed statute but rewrote it in clear violation of various constitutional provisions, including the separations of power clause and principles of comity. Defendant's jury was instructed pursuant to a statute that never existed. A California court has no authority to rewrite a California statute, and neither does a district court sitting in New York. Even if the government had the authority to charge defendant under the 2015 version of Section 120290 of the California Health and Safety Code, the statute does not pass constitutional muster. Most obviously, the statute is void for vagueness both on its face and as applied to the 2. The bill analysis for the 2018 enactment sets forth the legislative history and rationale for repealing the version under which defendant was prosecuted. https://legenfo.legislature.ca.gov/basis/bill_client.xhtml?bill_nd/bill_id=sign 201720180 Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 39 of 63 page ID hashtag 10936. 33. Defendant. The doctrine of vagueness guards against arbitrary or discriminatory law enforcement by insisting that a statute provides standards to govern the actions of police officers, prosecutors, juries, and judges. Sessions v. Edemiah, 138 CT 1204, 1212, 2017. As written, the 2015 law fails to provide adequate definitions that put individuals with any chronic and potentially contagious diseases on notice of what amounts to criminal conduct, including communicable diseases that are not sexually transmitted. By way of example, nearly 50% of the population has herpes simplex I, a communicable disease. Under the 2015 statute, anyone with herpes simplex I, also known as cold sores, who kisses another person without disclosing that they have herpes simplex I, is guilty of a misdemeanor. Misdemeanor. Even if the afflicted person has no active infection, outbreak, and does not pass the disease along to the recipient of the kiss. Under this statute, parents with herpes simplex I, again 50% of the population, would be prohibited from kissing their own children. One cannot imagine how many arbitrary prosecutions could take place in this current era of a pandemic if this law was in effect today. Even if the elements of the statute were as the government alleged, insufficient evidence existed to sustain the charge. The government did not prove that defendant was contagious, infected, or had the capacity to transmit herpes during the sexual encounter he had with Jane in May 2015. Additionally, the government cannot show that defendant acted willfully with knowledge of the consequences. Presumably, the government assumes that the consequences is transmitting the disease to the person exposed.
Let me pause it. I just want to jump in. Now, she said that the government did not prove that Robert had herpes. And I was listening, to the trial and the people that was translating and, giving us the information and the transcripts. And I kept trying to go over. And I'm like, I need some more transcripts. I need somebody to send me some transcripts. I'm like, I ain't gonna lie, I can't afford to buy them transcripts. The supporters was giving money to bloggers to get the transcript. So I'm like, I'm not going to spend that kind of money on the transcript. So I'm trying to find the transcripts so I can read them and break it down and stuff. And I kept looking. I'm like, I don't see them displaying all this stuff that they put out there in the public that they had. They had all these videos. They had all this kind of stuff, and they allow this Asriel to get up there and say she had herpes and stuff like that. And then you got Nicole ass trying to get up there and cross-examine, didn't know what the hell she was doing. And I'm like, I'm still not seeing the records. I don't see no records that the government showed saying that Robert has herpes. I did not. I was looking at the transcripts. I have not seen it. Did I overlook it? Y'all tell me, did I overlook it? Because I don't think I did. Because I try to go over it, over and over it again, which I'm gonna have to go back and do 2 years of going over things that I have. And I'm glad I still have my notes and stuff so I can get my memory back. See, they didn't know the fans was going to expose the foolishness. Yeah. And I mean, and I know he appreciates his fans because, hey, the fans, I just put it like this: if it wasn't meant for the fans, to be honest with you, a lot of this stuff wouldn't be out like it is now. Confronting these people and stuff like that. I ain't gonna lie. They wasn't looking into this stuff like they really was supposed to. And kudos to his fans. And so, yeah, guilty for having a cold sore. Um, I'm just so sensitive. My skin's so sensitive. People kiss me. That's why I don't kiss. Like my glam baby try to kiss me. I'm like, and stuff. And cause I would get a sore, and I ain't got time. But yeah, and I don't have herpes, so you can't say that. But they didn't display no medical records. Did they explain? Did they display medical records? Workers on some tape too. She tried to make sure they never found out about it. Mm. Well, all this stuff, I always say the truth. You can bury the truth, but it will rise like a spirit. And just when you just sit back and be humble and let God make his moves and stuff, things will start coming out. Need to come out and confess, Lisa. These people, when you did keep lying and lying and lying, you ain't gonna, you catch yourself lying, trying to cover up a lie. So you covering up lies after lies after lies, and these people, they're not gonna tell the truth. They're not. It's everything is about money. But you just let God do His work and just be humble and prayed up and watch Him do His work. But I find it very, very weird.
Exposed. But effective treatments exist for herpes that significantly reduce outbreaks and the likelihood of transmission. If defendant was consistently taking Valtrex in April 2015, it cannot be. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 40 of 63 page ID hashtag 10937. 34. Said that he willfully exposed Jane with knowledge of the consequences, particularly since Jane was not infected with herpes in April 2015. This racketeering act cannot be sustained where it was based on a repealed law, was rewritten, and was facially unconstitutional in any event. B. Racketeering Act 8B, coercion or enticement. The government alternatively argues that defendant is guilty of the Mann Act stemming from his April trip to California, because defendant knowingly persuaded, induced, enticed, or coerced Jane to travel to California. Insufficient evidence exists to prove that defendant took any action to induce, persuade, entice, or coerce Jane into traveling to California in April, May 2015. Quite the opposite. The record shows that Jane's mother purposefully and strategically enticed defendant with her 17-year-old daughter, comparing her to Aaliyah at various points. GX 233, the government takes great umbrage to this characterization, but the record speaks for itself. Although defense counsel did not make much use out of it, Government's Exhibit 233 offers powerful evidence showing that defendant had no reason to induce, persuade, entice, or coerce Jane into going to California with him. Text messages introduced by the government show that Jane, with the guidance of her mother, enticed defendant, who reasonably believed Jane was 18 years old, to bring her to California. In short, when Jane traveled to meet defendant in California in April-May, she required no enticement, persuasion, or encouragement of any kind. On April 11, 2015, Jane attended one of defendant's concerts in Orlando, Florida. After the show, someone provided Jane with defendant's phone number. R775, Jane attempted to text the number on the phone and gave the paper to her mother. ID. Although Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 41 of 63 page ID hashtag 10938. 35. Jane did not reach defendant. Jane's mother began texting the defendant posing as her 17-year-old daughter. R. 778-779. Jane eventually communicated directly with the defendant via FaceTime and told the defendant she was 18 years of age. R. 781. On April 20, 2015, Jane's mother, still posing as Jane, initiated text messages with defendant and arranged for Jane to meet the defendant at a hotel in Orlando. Government's Exhibit 233 shows that Jane and her mother knew from the start that defendant was interested in Jane sexually, believing that she was of legally consenting age. Before Jane's first meeting with defendant, Jane's mother texted Jane, stating, "This man trying to screw, but I'm trying to make it business. He knows you're a singer, but he ain't playing he want to FT, fuck tonight." GX 233, despite that Jane and her mother were on notice that defendant was interested in Jane sexually, Jane's mother encouraged Jane to meet defendant. She told Jane to keep defendant's curiosity piqued and advised her about what she should wear to effectively entice him. ID. During her in-court testimony, Jane testified that she went to meet defendant solely to audition for him, but her contemporaneous text messages revealed that Jane was more interested in defendant for personal and romantic reasons. Jane texted her mother, "He's so fine." ID. When Jane's mother told her to be ready to sing something, Jane said ugh, suggesting that she did not actually want to audition for defendant. Jane's mother encouraged Jane to tease defendant, but not to do anything sexual with him, since he would then lose interest in her. Believing that he was speaking to an 18-year-old Jane, defendant texted Jane's mother that he was staying on the tour bus, but was going to get a hotel room for their privacy. Jane's mother then shared that message. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 42 of 63 page ID hashtag 10939. 36. With Jane, texting. "Yep, he said he's staying on the tour bus, but he wants to get a hotel room for just y'all so y'all can get away from security and managers, etc." GX 233. Jane's mother gave Jane some final advice before she sent daughter to meet defendant, who believed Jane to be 18 years old. "Be prepared to sing 3 songs. He said he will meet you and listen to your song. Please have your glasses off, hair to side. Mama knows best, pretty hurts, and third your choice, don't yell. Put on a show, dance, grab his hand, shimmy, wiggle, sit on his lap, entice him. While singing it's all about performance. This your chance and opportunity, don't blow it." Jane's mother even told Jane not to look grown. Emphasis added, Take off that ugly ass lipstick. I told you he don't want you to be grown. I told you to keep hair curly. That shit look a mess. You need some jeans or shorts. You trying to look grown. He wanted you cause you look young and innocent. That's what he want, not a little girl trying to be grown. You're a damn fool. Defying her mother's advice to merely tease defendant, Jane engaged in sexual conduct with defendant in the hotel room. Jane stripped down to her undergarments and walked back and forth for defendant. R. 791. She later acquiesced to removing her clothes, testifying that she got on top of him backwards and he did lick my butt. R. 793. After the sexual encounter, officers arrived at the hotel room and knocked on the door. R. 793. After arranging for Jane to meet defendant in his hotel, Jane's parents apparently called the police. Point 3. R. 793. Jane described defendant as nervous and anxious, asking her to confirm that she was 18 years old as she had represented. Jane testified at trial. After he, defendant, looked through the peephole, he made me go into the restroom immediately and told me to get dressed. And he said, "Are you 18? And I said, "Yes." And he said, "Don't lie to me." And I said, "Yes." ID defendant opened the door. 3. Although defense counsel.
Okay, let me pause this, you guys, because I have it like this right here because I'm gonna go back and I'm gonna just cut this clip right here. So I want to say something in the middle of this. So we remember Azriel, reading the transcripts. She actually didn't dress like her mother said, according to Azriel on the witness stand. And like I said, somebody's lying. Is the daddy lying or the daughter is lying? I still have those videos. Like I said, I'm gonna be dropping them, and so it's gonna be behind. I'm behind schedule, you guys, with these videos and stuff. So I want to remind Choke that I did ask him about, doing the using his clip and stuff like that. I want to remind him of that, but I haven't dropped it yet. But you remember she said she had on this skippy skirt. She had on I think a halter top or something like that. So she did go in there dressed up like an adult. So I think she said she got dressed over in one of her friends' house, and things like that. And also, I want to point out this: when the police went to the door, they checked Azriel's ID. So, like I keep telling people, just think about it. You have a guy that beat a case and trying to make sure he did everything that he could do to make sure he never get in a situation like that again. So checking the ID, you have the law now checking the ID. So the law comes in and want to verify that you of age. So which you had the parent, trying to set it up and say that, my daughter is in the room with him. And so it seemed like Alice was trying to have her to tease and dress like a kid. So when the officers come in, be like, this is a kid. But they gave her ID, but she gave them her ID. So they checking the ID. So if she was underage, because I know in Florida they don't play that, especially in a hotel with an adult that's not your guardian or parent or something like that, because it's gonna be questionable. And so everything was cool. According to Azriel, she even said that they gave Robert their card and said, if you ever need security when you come in this area, let us know. And that wasn't even celebrity status. So also, why the prosecutors, they got all these bad act witnesses, but why they didn't get the officers that checked her ID? Because I'm pretty sure it's on record when the parent made that phone call. I'm pretty sure it's documented, who went out there to that hotel. So these parents tried to set him up then. So that didn't work. So okay, let's keep going. Let's keep going. Let's see how far we can go. Because I have a video, about Angelo. Because I wrote down the dates. You said that you found out about Azriel and Robert in what was it 2016, I think. But you wasn't furious until 2018 after he turned you down for a deal. Because basically the parents was pimping their daughter, and this is my opinion, pimping Azriel so they can get their come up. So when Robert denied them, all hell broke loose. All hell breaks loose. So now, listening to Tim seemed like the Clarice had something to do with it first, and then they got in it and stuff like that. So like everybody is just trying to twist things. And so you had the Clary daughter to get on oh Lord, the poor child name. What's his name? The blogger. I swear I'm blank. I see his face, but she was on his page and I went on there. Because I wanted to, put my 2 cents in. When I actually go on somebody's page, they know I'm there because I'm gonna actually acknowledge and speak and how you doing or whatever, put up a little thing. And so it seemed like she's trying to clean up the mess that her parents, made, and she's trying to say, look, I'm sick of this. I'm trying to live my life. And it's just basically she basically getting on there saying that I'm sorry we got myself involved in this mess. And she's young and she's listening to her parents, and like I told is it Jada? I think her name is Jada. I guess that's her name. Savage. And I said, well, first of all, you gotta realize if your parents doing some scheme shit, they ain't gonna tell you nothing. Parents do stuff behind your back, and they ain't gonna it's not like they're gonna sit there and give you every details of what they have going on sneak shit. They're not gonna tell you that. You was a kid back then, and you 21 now, and you growing up, and you seeing things, and really and truly, I think this the Savage daughter, I think she actually see this stuff. She see this stuff, and she really want to say something, but she can't say anything. But she's trying to come in and say, "Hey, I I understand. I'm just gonna say alleged, but it's like she tried to go in there, but this and but that, and I like how the blogger did it. Y'all tell me his name because I swear to God I cannot get his name, and I'm sorry because I'll be forgetting stuff. But I see his face, and I like how he flipped the script on Jada and say, put allegations on her boyfriend. He said, well, you got Stockholm syndrome. Because I put in the chat, I'm like, hell, we all got Stockholm syndrome. Hell, I'm pissed off as hell, but if this, and hell, I'm sorry, Debo. Thank you. I'm so sorry. I swear, his head, he's in my head, but it just I cannot get the name out. So I'm still dealing with post COVID, so y'all have to forgive me, you guys. But I like how they did what they did, with her. But those Claries, they know what went down. She's only going by what they are telling her. And she just only speaking on what she know. And like I told her, yeah, you was wrong for doing the song, and because you going by hearsay. You went by hearsay, and when I somebody sent me the link with the Savages, and they were talking, and I'm listening to the Savage lady. I forgot her name. So Tim's wife basically was speaking on what other people was telling her. You understand what I'm saying? So when I was listening to people in the camp, and I was seeing the text messages that Dominique was talking about with Azriel. Azriel was in there, and I keep telling everybody she was in there to get everybody out of there, any means necessary. And so when they the savages said that the lady called, what's her name? Ashanti McGee. So I have a few of my notes with everybody's name on it so I can just try to remember. So Ashanti McGee, and I was saying this, I'm like, Ashanti McGee allegedly stole, and Robert said, you got to get the hell up out of here and don't come back no more. I have forgiven you, and I have forgiven you, and I have forgiven you. And so you have these women in there trying to compete to be in the number one spot. So what they gonna do? They gonna go on online and get in your DM and tell you, well, your daughter in here doing the nastiest thing. And so I was pissed off when I heard that that's what Tim said. But if your daughter, grown ass daughter, decide to lick toes or whatever she was in there doing, that was her prerogative. So, and I'm like, okay, maybe somebody telling you this because they have to get the TKO. They have the TKO. So they mad as hell. So they going to try to get everybody the hell up out of there. Then you have this gorgeous lady coming there, Joy, beautiful, and and from what I hear, actually, Azriel was there before Joycelyn. Joycelyn. So she was there. Azriel was there first, So when you heard when they had that fight, you can hear Azriel say back to second, like she's like, talking like I'm back and you back to second, being number two. You back to being number two. Those was her words. What happened to Azriel's sister? The one that claimed she was at the hotel and couldn't find her. See, that's what I'm saying. Why she didn't testify? See, that's what I'm saying. They got bad act witnesses, and to me, I swear, this case seemed like it was that people were paid off. People came in to say, well, we're going to come in, we're going to pretend like we representing this guy, and we ain't going to do anything, so y'all don't have to worry about it. And you have to question it. And so a lot of people try to ask me about that man. I'm not going to promote that man and what he's saying about Nicole, because that's something we already know. Yeah, if people look over what Don Russell been telling them, he been telling y'all about Nicole for the longest. It's people that was actually there. Even Don Russell was talking about how Nicole would do, and she used her female traits to try to get into Robert's head. So she went in sabotaging things. She went in there, even though we was mad at the damn attorney, the Greenberg, even though we was pissed off at him, she was the one going in telling him all that. I know people was writing, but she was going into that jail telling him about Greenberg. This is what Greenberg is doing. And then y'all, we already know this is old news. Why old dude thought he was saying something. This was old news. She was the one allegedly, giving money to keep keep them up and keep them going. Because from what I was hearing, that he wanted a female to handle the business, and then I think the doctor's wife allegedly was, helping out, financially, getting money to them and stuff like that. And he didn't trust, allegedly. Now I'm saying allegedly, he didn't trust Keith to, financially, keep them going. So he was having Nicole allegedly to do this. And now y'all don't remember that went over y'all head too. So I'm like, people like talking about old dude, Shahaz. I'm like, he ain't talking about nothing we already know. Because even Don Russell, he was like, no, she got to go. It's like, it's some shady stuff about her. He said, you know where she come from? You know who sent her? It's like, he said, then she come with them little short skirts and how he said she don't act like an attorney. You know, he's like, how she be touching on them and stuff like that. She don't act like no attorney. And, he even felt a certain way about Mr. Greenberg. He was like, for a man to come in and tell my man, I thought I was gonna go and have an orgy with my wife, and he was like, that ain't how you come in when somebody hire you and they're fighting for their life and they got some stuff going on and they need you to come in and help, and that's the first thing you come in there talking about, an orgy. So people was looking at that, side eye. So if people wonder why it take 2 years to get the right attorney, because you had the insiders up in there fighting over money issues and who had the say of everything, and I like Greenberg, and and not trying to sit down and do what's best for Robert. Everybody had an ego that was in his camp, and they wasn't looking for the best interest of Robert. And I still say what I say, and I'm going to continue to say it. When you got somebody posting up about shopping and all that kind of stuff, and they can't even mention Robert's name in their post, but you all in New York, and from what I hear, allegedly, they were staying in the Airbnb on Robert dime. They flew in on the plane on Robert's dime. Not just say alleged. So I'm just saying, it's just a lot I can point out, and I really want to get those transcripts so I can go through them real thoroughly, so I can chop them a little bit and do little small videos explaining why I see bogusness on that, especially that old Cunningham thing, that little heifer. This shit, hell, they know. Be quiet, girl. So you go off.
Counsel sought to present evidence that Jane's parents intended to set defendant up and extort him. The court precluded that testimony.
Yes,
Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 43 of 63 page ID hashtag 10940. 37. And the police checked Jane's identification to confirm her age before leaving. R. 794. Defendant was present when police officers checked Jane's identification. Rather than calling it night, Jane again removed her clothes and got on top of defendant to continue their sexual activities. R. 795. After her first encounter with defendant, Jane told her mother that defendant had asked whether he could fly her to meet him. Jane told her mother, I said do. Jane continued to communicate with the defendant via text message and by phone, and continued to spend time with defendant in Orlando doing normal dating activities such as seeing movies and eating out. GX 233. At one point, Jane's mother got frustrated with Jane for not prioritizing her music with defendant. On April 23, 2015, Jane's mother texted her, "You need to let him hear your songs. Let him see your video. You trying to date the man you need to let him see. Your shit." Emphasis added. Jane's mother also continued to encourage Jane's relationship with defendant, telling her to be a little feisty, stating he married Aaliyah because she was feisty, she didn't let him run over her. You need to be different than the rest. Later that evening, Jane's mother texted Jane, "You are silly, that man ain't trying to do nothing with you musically, he want to fuck period cause he like young girls." Jane reassured her mother that defendant was willing to look at her performances and was patiently waiting to look at some of her videos that her mother had emailed her. On April 24, 2015, after defendant had left Orlando, Jane's mother instructed Jane, "You better be texting him so you will stay on his mind." Later that day, Jane texted her mother about flying out to see defendant in California. Jane, and I talked to R. Kelly. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 44 of 63 page ID hashtag 38. Mom, yeah, about what, Jane? LMAO, about flying me out, Mom. Oh really? When, Jane? Yeah, whenever I tell him he can. Tomorrow if I choose, Mom. Oh yeah, on April 28, 2015, Jane traveled to Los Angeles, California to meet
Now let me pause this. Now she said she told her mama in the text messages, tomorrow if I choose. She didn't ask her. I think people need to go back to the beginning and play catch up because they act like they ain't heard shit or know shit, like when this and that. So this is again, and a lot of people need to understand what I'm saying, because yes, I am a female, but I'm gonna keep it 100. I'm gonna keep it 100. This is another example in of a mother pimping their daughter, and I'm gonna keep it 100 again. This is another example of people. If you listen, the mother is trying to have her daughter to use her vagina for an ATM machine and a resume. She is coaching her, listen, this is your resume. You're going to have to tease him. You're going to have to do whatever you have to do. Now, y'all remember this. When I said this about how they blaming everything on the men, right? And they try to say that these men, they this is what they do, and they try to have us to have sex with them so we can make it, and they don't accept us, for our brains, and they don't accept us for this, and they don't accept us for that. But this is what y'all are doing. So you have to look at it. The mother is texting. The daughter is keeping up. They keeping up with each other. And this is what she just said to her daughter. You know he like young girls. You know he like girls. And this is what she keep putting in her head. So if you know this man allegedly like girls, but you pushing your daughter and instructing your daughter to use her vagina for a damn ATM machine and a resume. So now y'all understand what I say to y'all when these women, these grown women teaching their kids, their daughters to use their bodies to get it, to make it, to get somewhere. This is what I'm talking about. This right here. Before this text messages came out, and the people that they ones that been following me, this is exactly what I've been trying to preach to everybody. Because this Me Too mess, I'm not gravitating to this Me Too mess. This right here is what needs to be stopped. This right here needs to be like those two parents that had the gun and knew that their son had a problem and he was upset. This too needs to be an example, just like them two parents. That son went in that school knowing what went down and killed people. So basically, this is exactly what's going on. This is like murder. When you this is taking somebody's life because you have a thirsty mother. And I say, mammy, we're not perfect parents. When I was getting my kids the hell away from a man and sending them to another state, this woman is pushing her daughter And if she got these bags under her eyes, it wasn't from no robber. And then they talking about what they call it, forced labor. What forced labor? Human trafficking is a $1 billion industry. This man wasn't pimping these girls. Well, these women. So I have to be careful when I say that too now. Display do not allege with grown popcorn popping. Yeah, popcorn popping. So this is I'm looking at the thing. So it seems like I think she cut Demetrius Smith a little short and things like this. So when I finish with this, I'm gonna put it on pause and then I just come back on it. But I want to do this here because I want to take this part and I want to send it to some people because I've been talking to some people, about it, when I can talk because sometimes my voice go out. But take your child and instruct her. You've been on the phone all this time. You on the phone with her while she at the concert. You on the phone with her while she at the hotel. And so then you have the daughter say, yeah, he asked me if I choose to. She didn't say, well, Mom, can I go if I choose to? And the mother all in there agreeing, being the friend and not the mother. Because my daughter, I have a relative and she partied with her kids, smoked weed with her kids, dropping like it's hot with her kids, hunching all on men's on the dance floor with her kids. And my daughter was like, Mama, you don't do stuff like that. You don't be having fun with us like that. I said, that ain't no fun. I'm your goddamn mama. I what it look like with me smoking weed and stuff with y'all and doing stupid shit when I'm trying to keep y'all from doing stupid shit. They feel like that's what it's supposed to be because see they see all the other mothers trying to be young and be they damn kids' friend. And I told my daughter, I am your goddamn mother. I'm your mother, not your damn friend. Go find you some friends because I'm not gonna do that shit. Even drinking like special occasions, that's what they'll see me drink, special occasions. Well, my kids when they was her age and stuff like that, and I have alcohol, I'll be in my room when the kids sleep in silence, drinking my alcohol. We're not perfect parents. Hell, we're not. But to do shit like that, because if my kids do some ignorant shit, it'll be on their own. They sneaking out doing this shit on their own. They did it, and they did it. And I ain't gonna lie. They was sneaking out. They was going see men's. I ain't saying no boys, men's. But I did my best to block it. Even though I married somebody when I was a teenager. I'm like, live y'all life. Stay young. Don't rush your life. Don't rush your life. Stay young. Take the opportunity to grow. But this is the example of what I was talking about, and people was mad because I didn't agree with this damn Me Too movement. The hell with it. Because this is what you got going on and being displayed. You have women having sex with men with money. They don't get their way. She worried about music. And you look at the music industry, it's not a guarantee. She was up in there getting what allegedly from what I was hearing, Azrael was getting 10,000 and more. But did the mama and the daddy tell her, girl, you better take that money and save it, and while you there, you need to, learn the music business and also go to school, go to college or something. But your mama telling you how to rub on a damn man. That's what I'm talking about. That shit right there.
Defendant with the knowledge and consent of her parents. R. 799, 814, GX 233. Jane continued to text with her mother once in Los Angeles. At one point her mother told her, "He going to be in your room, but naked with one of his songs playing, LOL." Government's Exhibit 233 reflects that Jane and her mother texted incessantly while Jane was in Los Angeles with defendant. Jane tells her mother at one point, "Crazy, this Aaliyah movie just came on and I just got off the phone with R." Mom responded, "Really crazy." Jane testified that she had oral sex with defendant in Los Angeles, but she did not share that information with her mother via text. R. 804 to 805. At no point did Jane express any apprehensions about being with defendant or ask her mother to arrange for her to come home. When Jane excitedly told her mother that she was riding defendant's tour bus to Stockton to attend his concert, Jane's mother responded, "OMG, exciting you riding on the tour bus." GX 233. On May 1st, 2015, Jane's mother urged Jane to take advantage of defendant, texting her, "It won't be star lifestyle if you don't get serious about your music and show this man you want to be famous like him. Once he tired of you, you'll be like everybody else. You better use this as your opportunity while you got him in spell." Jane's mother. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 45 of 63 page ID hashtag 10942. 39. Then said, "You should text him and be like you know you gonna be my boo and see what he say." To which Jane responded, "LMAO." Jane traveled independently to meet defendant in Stockton, California, where he was performing on May 1st, 2015. RA 18. She stayed in contact with her mother the entire time. At one point, Jane explained to her mother how she ended up going to Stockton to see defendant's performance. "I told you. He asked me did I want to come to his show. I said of course, and he said okay then. Let's pack this stuff up. He was even putting his stuff in my bag." Jane and her mother remained in constant communication before defendant's show. Jane's mother instructed her about what to wear and made suggestions about how she should behave at defendant's show. "I would blow him lil kisses and wink at him and bite the tip of my finger, mess with him real good. Do something seductive, then make a silly face. LOL. Jane and her mother continued to text throughout defendant's performance. At one point, Jane and her mother exchanged the following texts. "Jane, he's singing this whole show to me, Mom. LOL to funny Jane. FRRRRRRR Jane. LMAO Jane. This man in love, Mom. OMG, you gonna marry him and have his babies, Mom. LOL, my son-in-law gonna be older than me, Mom. To dang funny Jane. LMAO. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 46 of 63 page ID hashtag 10943. 40. Mom, well you better get signed first then married second. Mom, he gonna seduce you tonight, Jane. LOL. Mom, you have to give him a massage before he go to bed. Jane, Mo, no, I doubt it. Mom, girl, you better, or he will get someone else too. Jane's mother continued to encourage her to seduce defendant. At one point, Jane told her mother that she caught feelings for the defendant. According to Jane, she and defendant had sexual intercourse for the first time after the concert. R. 819. At no point during her travels with defendant in California in April and May 2015 did Jane disclose that she was 17 years of age or that she had lied to him about her age. After the trip to California.
So let me pause there too, because let's go back. Let's go back to the text message when she was in California. Now, I'm sorry, guys. I'm on the other screen. I was looking at the words so I can get it implanted in my head. Her motion, but she had a text message stating that when she was in California, that Robert text her and said, sorry, I didn't get a chance to meet you. Take this opportunity to soak in what you learned so you can have, once you become a professional in the industry, you'll be well shaped or something to that fact. So he didn't even meet her in the he didn't come to that room. He didn't come to the room because after the concert, he had an after party. And so listening to everything and listening to testimony and stuff like that, Adrielle used to always play sick around the time of these after parties, you know, because you got to be a certain age to get into those after parties. So at the so you he wasn't even around her at that time. Because in her text message to her mother, she stated that he said, I didn't get since he said I didn't. He said, I'm sorry I didn't get a chance to meet you. And this was in California. So I wanted to, that popped up in my head. So I just wanted to put that out there too. Last time I checked, Kelly hasn't signed one artist besides who body, but they already decided to cash money. If human trafficking is to be stopped, it starts at home. Amen. At home, it's the parents that's pimping their kids. It's the parents. Jesus. Y'all remember I did a video, I was upset with the judge not allowing Alice or Angelo to be a witness. I'm like, are y'all serious? How can y'all tell a person that they can't subpoena somebody to get up there and speak? Or are they telling the judge, well, if we call the parents up there, that the defense can't cross-examine them? And I said, what kind of shit is this? What y'all telling these people they can't defend their client? Because I had to cuss it. I had to edit that video. I did so much cussing on it for Judge Sidebar. All of that stuff was a violation. Like, how in the hell these parents were involved? You looking at the text messages. They couldn't speak on it. And you see Cannon trying to bring it out. And every time you got damn Judge Sidebar striking shit, striking her ass off, overturning, overturn. So let's do a sidebar. When Cannon started getting deep into him, shame on you. You shame on you. Why are you doing this, Cannon? And he drilling the hell out of him. Bringing all it out, And I got witnesses, and I wasn't saying anything, but I was sending him information, and I was pointing out some things. And when I was looking at the transcript, Cannon used it and used word for word from what I said about the stuff. I promise you that. I got witnesses on that. I promise you. I just don't just say a thing because I know how people talk. Oh, she trying to sit up here and say she doing this, and that. I ain't got to lie about nothing. That's how I knew that Cannon, was trying to do whatever he could, and he took the information that people sent to, go in and go for the juggler. Because I had information and I was sending it. I did my best. I was trying my best. I was waiting on the people to tell us what's going on and who is on this witness stand, and if they're gonna be on the witness stand tomorrow, who they think gonna be on there. And I try to get that information to them, but it was so overwhelming. I'm like, ain't nobody talking. Y'all gotta give us the information, because I stayed up all night. I knew the judge was on some BS after she stopped the defense from asking questions about these women's sexual past. Yeah, they wouldn't even say anything about that. But you, as a juror, you would want to question yourself, especially that Cunningham girl when she said She got on top of him. She got on top of him. And usually when you uncomfortable and you doing something for the first time, you ain't gonna straddle on top of nobody. They gotta teach you some things. So she said she gets on top of him and she straddle him and she gets sexually into him, and then she asked him about a condom, and she said he didn't have one. The Cunningham girl said he didn't have one, and she said she pulled one out of her backpack. So she went there with the intention of having sex. She didn't have to go into them. You see what I'm saying? Like they didn't these. That's why I said them jurors. No, something wasn't right. Cause I'm like, damn, I'm looking side eye as trying to. It's times I just throw all this to the side. Like, look, just throw it to the side that you fight robber, and put yourself in the public shoes. What would you think about these testimonies? How you feel about these testimonies? And that's exactly what I was doing. And I'm like, wait a damn minute. And don't nobody see what I see. These jurors don't see the shit. They ain't asking no damn question about these damn women. This is sad. If we talk about sex trafficking, we better get deep into it. And that's why I do what I do. Because I said Robert's case is pointing out so much stuff and bringing out so much stuff into the light. And maybe it took his situation to bring all this truth out. Because I said, Alice went MIA for a while, and I was like, I was like, it wasn't because Don said what he said that Robert got a piece of her, and Angelo and her had some words because she went MIA, or did she go MIA? And her husband told her, look, this is what they showing me, and this is what you got going on. I need you to step to the side. What the information and the evidence of Azriel's sister being kicked out of the damn studio because they got footage. What all this evidence is? What the hotel footage and stuff is? What is stuff is? Well, all these tapes and stuff that they said they had, pushing all these damn baskets in the courtroom like they had so much shit, the damn cameras running behind them like damn food, and all they had was some damn paper. I was waiting on some damn tapes. And again, I ask you, will you have somebody in your freaking house stealing? You gonna yell and cuss their ass out? Cause hell, I do it to my kids. If you come to my house and you touch some stuff of mine and you ain't got no business, I'm gonna cuss your ass out. Who wouldn't be angry? And then I listened to the Savage daughter when she said that. So I said, okay, so now we're getting somewhere. So now you saying that a person to be angry. I said, so Robert didn't have a right to be angry because she was talking about her dad, saying that her dad, sometimes he'll get angry and he'll yell and he'll say things that he don't mean to say. I'm like, oh, okay, so he can do that, but everything that Robert does is a problem. It's a problem. Let's keep going with this man.
California. Jane traveled to meet defendant in Las Vegas, where he was performing. R. 821. No rational juror could conclude that defendant enticed, persuaded, induced, or coerced Jane to travel to California. Jane's contemporaneous conversations with her mother show that defendant invited Jane to join him, and she excitedly accepted. When her mother asked her when he asked her to travel, Jane told her mother, whenever I tell him I can. Tomorrow if I choose. GX 233. By her own admission, Jane chose to travel with defendant because she wanted to, and her mother encouraged her. While this court concluded that Jane's parents' testimony was not relevant for the purpose defense counsel sought to introduce it, Jane's text messages with her mother introduced as governments. For caught feelings is an expression that means when you meet a girl/guy that you like and it starts to have an effect on you in an emotional way. https://www.urbandictionary.com/define.php ? Caught %20 feelings. Case 1:19 CR 00286 AMD document 273-1 filed February 27, 22 page 47 of 63 page ID hashtag 10944. 41. Exhibit 233 were highly relevant evidence that defendant took no action to induce, persuade, or coerce Jane to travel with him. Jane was eager to travel with defendant and caught feelings for him as she admitted and concealed her age from defendant so she could pursue a relationship with him. The government's evidence fails to show that Jane was persuaded, induced, enticed, or coerced into traveling to California. 7. Racketeering Act 9, Mann Act violations. Jane, the government charged defendant with 4 Mann Act violations, stemming from a trip with Jane to California between September 2015 and October 2015.
Okay, guys, we already know the situation with all that. So at the end of the day, we're going to continue to point the lies out from the truth. If anything new or different on here, because from what I'm looking, I was trying to, glance through it real quick. I will put it on there. But I wanted to get this right here because I want to send it to some people because I told them that they was like, you lying. I'm like, no, I'm not. I said, I'm going to get it to you. So I want the public to know the lies. And there's nothing Angelo can Instagram or tweet to try to cover up these damn lies. Because I said it. I said, why the government working so hard to keep them parents out of their damn courtroom? This is why. And so I feel that the prosecutors are some dirty ass people, slimy ass people, and they promote shit like this. Them 3 females, they ain't shit because they promoted this. They allowed this to go down. They gave these people immunity. They did their best to keep dirty ass, slimy ass people out of the courtroom like the savages in the damn Claries. And allowing them to do the shit that they doing just so they can get a high status win. It wasn't even about Robert. It's just I want this trophy so bad. This was all about a trophy with these 3 women. A shame on them prosecutors, and I said it before. A shame on you guys, on you 3 women to allow this to go down. A shame on you because you want to win. A shame on you. And a shame on the Alice and her dad, Angelo. Ashamed. Y'all ought to be ashamed. I don't care how this look because y'all lied. But y'all, this is it's embarrassing. So I'm gonna get off here because I'm stopped up and I still can't sleep, but I want to try to lay down and get some sleep. You guys, I want to try anyway. My doctor told me I'm going to collapse if I don't get some sleep because I probably sleep every 20 minutes. For the same chicken head, you said that when we was breaking down the Jane, though I remember you said that as well most of us thought Joy would flip. Yeah. I'm telling y'all, it's like, because my videos is long, that's why I'm going to break them down. But we've been talking about this, and I'm so glad. We have to allow people like Jennifer and other public figures to help us put this stuff out there. We've been sitting here doing our best trying to get it out there to his friends, to people that know him. And I told y'all, I said, just like with us in real life, it's gonna take a stranger to help him. We looked up on the wrong people, but like I said, just like with us, it's gonna take a stranger to help, and that's exactly what happened. So thank you guys for tuning in to Texas Black Diamond Entertainment. I really appreciate you guys. Thank you so much for coming in. I had an intro. I have to put in another format, and I have to figure out how to do that later on. But you guys be careful out there. I saw the date posted November 14th as we was 17. So she would have been 18 the next month. 2015 concert, and she should have overlooked that, just like the IRS does not if a child was born. It's I don't know. I don't know. But for me, like I said, the police verified for him in that room that this lady is of age. They didn't say anything. They didn't arrest him. They didn't take the child to the mother. The parents out there, they claim to be outside in the lobby of the hotel, and she didn't come out. So we're not questioning these women, these young girls. Ain't nobody question why is it so easy for y'all to jump on top of somebody. He asked me, and I got on top of him. You wasn't scared. You didn't bag up. You wasn't ashamed, or it didn't take much. It didn't take much for you to drop your draw. No morals, no value. And I see why. Because she only know what she's been taught. And she followed the wrong people, just like her daddy and Larry when she left. So I don't know. I don't wish. I ain't gonna wish. I only what I wish is Azriel clean it up, clean this mess up, and just be straight up. Like, yeah, this is what my parents did. Yes, I was in love with them because they were saying that she cared about them. Thank you so much, I will. But she wanted everybody else up out of there. But her mom was instructing her. So I told y'all she was the she devil up in there. She was like the Tasmanian devil, like, from one of the girls, I got the text message. Everything was good until she came up in there. She came up in there to destroy. Everything, it became a mess. Everybody was fine until she came. And she came to destroy. So whatever that it was, so I don't know. But it's a life learning lesson for everybody. All of us. Robert, um, Azriel, Dominique, just everybody. It's just a life learning lesson, especially to know what kind of friends you got around. The photo, the setup is real. Yeah, I wanted to keep that photo up because the Jennifer Bungie was talking about Azriel. Um, Obviously, she wasn't a stranger. She said that she was being licked in the behind. So obviously, if this your first encounter, that is some strange stuff. You not gonna want to deal with nothing like that. Your first encounter with a man, anyway. So obviously, she was sexually active before. And Kannick did his best to try to bring that shit out. He did his best, but that judge Ann was mad at his ass. Shit. She was like, I done told you. He tried to slide it in there anyway. He'll slide. He said, I'm sorry, then he'll come back again. He asked a question like, well, I'm trying to see what's going on because it seems like you're not allowing me to finish what I'm trying to do here. Because he did check him. Kennick checked the ass, Judge Sidebar. He did his best, and kudos to him. A lot of people say he shouldn't have got on the case, but it's been a messed up situation if he didn't. You know, Thomas tried to point out this stuff in his motions and stuff, and she just went for Thomas' neck. He tried to point this stuff out about them parents and not allowing them to bring out stuff, and he tried to argue her, and she shut him down, and they just didn't have a winning chance with this woman. Someone said that makeup is part of the plot. They have philosophy. Yeah, because just pay attention to her interviews before that. Not even but a week before that. Then all of a sudden, so who did a makeup? Who y'all think did that makeup? Because then y'all said one of the blogger's daughter was doing the makeup. Did the blogger's daughter do the makeup to try to help her look like she was beat up? She was very recalled the interview that she couldn't wait to have salad. Participated with the backdoor activities. See, that's what I'm saying. So what was the guy named Bobby and his son? All of these people was relevant, and so something happened. Cause I swear to y'all, in y'all talking about he had witnesses ready to get on that plane. Even Jerronda Pace, trial friend, she was ready. She was ready. Them people was ready. So if someone right, we gonna find out. I hope she find out. And I put it like this: Judge Ann can deny all she wants, but I have a feeling if when they take that to the appeal court, them judge gonna see the I forgot what they call them. It's not in my brain right now, but I call them your magistrate. They're gonna see the bull crap. They're gonna see it. Cause see what I think feel like with Judge Ann, she tried to have no cameras in there. She limits seats. Um, she aggravated the journalists. She wouldn't allow the journalists to get certain things that they was entitled to. They have to try to put in. So they was like, the hell with it. It's just too much. I'm not gonna be flying out here and we can't do this and we can't do that, and we're not able to cover it like we need to. So the hell with it. So it just seemed like everything was done to sabotage, to keep people from being interested in it. So thank God that his supporters didn't give up, didn't give a damn. They did whatever they had to do. You had one that even lied so that they were family and lied so they were one of the jurors to get in, even though they got their ass kicked out, but his supporters did everything that they could to try to bring out the truth. And, she had, oh my God. Yeah, because because I was looking at that, and then on her Instagram, she was looking good. She had no bags on her eyes or anything. So did they tell her not to get no sleep for a week? And I know her blowouts are straighter than that. When they blow out her hair is blowed out straighter than that. So, and then you can look at that makeup, the little black makeup over her eye. That's all they put up there. They didn't put no gold or no kind of nothing. There was a setup to make it look like, oh my God, this poor child looked beat down and terrible. Because I remember I told y'all, I said they trying to get a lawsuit. Everybody trying to get a lawsuit. Everybody trying to eat for free. And Robert told them already that the welfare line is closed. And he should have closed the welfare line with them women and sent them home and worked on his craft. You know, one of his buddies tried to tell him that he'll remain nameless right now, but he tried to tell him leave them girls alone and focus on your career. You ain't getting no younger. You ain't gonna be able to run up and down this stage. Send the women back to their mammoths and pappers. Leave them at the hotel. Leave them at on the side of the road. Just leave them. Get rid of them. You don't have money to be taking care of these women. This is what was told to him. He got cussed out for saying it. He said he cared about them. He loved them. He said he loved them. He don't think they'll do anything to hurt them. And I love them. And I'm not gonna do that because then it's gonna make me look guilty and I ain't do anything wrong. So he just sent him home just because he didn't want to look guilty. So we 3 hours into this. I'm gonna break this video down. The motion is long. What page we on? Do y'all remember? Let me see what page. So we're on page 48. So we can try to do this tomorrow if I'm up to it, if I'm feeling good. She already looked from every funeral. Only Mr. J. How many new hours should be reporting on the motion? That's what I'm saying. Um, Stand up to be counted. If we can get all his supporters to just bomb rush, CNN, who else? All these people, they reported on it. Um, that's why I want to do this clip right here, and I want to send this clip. I want to send this clip to TMZ. I want to tag as many outlets I can on this because I'm gonna edit this part. But I want them to report this. I'm be like, y'all reported all that he say, she say. I want to know how y'all feel about this. Now this is some juicy stuff. Y'all wanted to put some juicy stuff out here. This is very juicy. This is a woman's act. And this is the woman act that I'm talking about. Now y'all remember when I said I've been trying to fight to get a woman's act put up? Now this right here, Alice and Azriel committed a woman's act. And I'm gone after that. Y'all be blessed. Thank you for tuning in to Texas Black Diamond Entertainment. Y'all have any information, please feel free to send it to my email or text me, and I'll reply to your text message. Y'all be blessed.